Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Adam David Long talks about the risks and rules around the use of AI tools using Bing's new terms of service. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I am here today with my friend Adam David Long. Adam, how are you today, sir?
I am great. I'm excited to be with you. I don't know your middle name, Mike Whalen. I would like to extend you the same
Nor
courtesy.
should you. There's both a middle name and a suffix. I'm a very confusing. It's the only way people differentiate me from all the other better paid Michael Whalens out there.
We'll cover that in the follow-up then.
Sure.
We won't get into that today.
Today, we are digging deep, swimming in the waters of modernity as they churn past us. We are talking about AI. I mean, everywhere you go, you see articles, you see webinars. We're all interested in this. But specifically, we've got to give some advice as lawyers to business owners in particular who are dealing with contracts around this stuff. And so we want to talk about it. Adam, we're going to use this document as an example. Let me share it with the folks at home. What is this document? It's from Bing. It says conversational experiences and image creator terms. What is this thing, Adam?
How do we unpack this? Well, this, of course, is from Microsoft. Bing is the name of one of many, many Microsoft trademarks. And one of the reasons, Mike, that this is a super interesting document is, of course, as you said, AI is at the center of everything right now. Microsoft is at the center of everything AI, both individually and through their investment in OpenAI, the creator of ChatGPT. And one thing that's quite fascinating about this relatively brief terms of service, is that this really is helpful to highlight a lot of issues that all companies need to think about as they move forward with incorporating AI tools.
Yeah, there's a lot going on in this space, and you have a weird background that helps you comment on this kinds of issue.
Nice
Weird background is the nice way to say, do you not know what you're going to be when you grow up? Adam, tell us about you. Tell us about your background. What brings you to documents like this?
Sure. I am an attorney and I'm an entrepreneur. I alternate back and forth every couple of years between practicing law for a while and then switching over to becoming a legal tech entrepreneur. I've got super excited. I've been excited and interested in legal AI for a long time, but of course, ChatGPT changed everything for me as it did for a lot of other folks. And so I've gotten extremely interested, Mike, right now in how the legal world is going to adapt to AI tools and how AI is going to adapt to the legal world.
Yeah, we've been excited about it too at Law Insider. And at the end of this conversation, here's the hook. I'm going to tell you guys about a resource that's coming up soon that we have been diligently working on. It's a premium resource to give a lot of practical guidance for this. But we'll get to that. Before we do, Adam, we're going to dig into this document as we are wont to do on this show. Who is this for? Before we get started, Bing, as I understand it, is a search platform. Those of you who get your PC computers, you know that it loads this up as if you're ever going to use this thing. But now it's entered the fore. What's going on with Bing in the background and this particular agreement? Who are the parties to this? Who are the players to this? We know that OpenAI is somewhere overlapping with this. Microsoft, as you mentioned, is somewhere. Who are the parties here?
Yeah, there's a whole lot of different players here. I think it's helpful to step back a little bit and talk about Microsoft versus Google, right? Which has been in some ways the battle for a long, long time now, where Google, of course, as we all know, has very much taken the lead as the place to search. It's the number one search engine in the universe, as far as the known universe, I guess I should qualify that. Microsoft released Bing. Forgive me, I don't know the exact date they did it. Maybe that even speaks to that in itself is probably an important part of this. Bing, of course, as many of us know, has been very much an also-ran compared to Google for many years now. And what's I think exciting for Microsoft right now is that by incorporating AI tools, they are really looking to even the odds against Google. And in fact, their CEO has talked about that. And an interesting component of this is Microsoft is a huge investor in OpenAI. still, I believe, who knows, right? This could change by the time this is released. But OpenAI is a separate entity, originally a nonprofit. Not sure what its status is right now. They are the ones that released ChatGPT into the wild at the end of November, just a few short months ago.
So this engagement right now, if I am a user, I am using Bing, and I'm creating all kinds of content, and we're going to talk about that. I'm both putting information into the Bing tool,
Exactly.
overlapping with this very large language model, but I'm also creating something out of it. And these terms apply to both what I'm putting in and to what I'm taking out. Does that sound about right?
Yes, no, that's exactly right. Microsoft is we'll obviously we'll get into specifics here in just a moment. Microsoft is saying we have a massive $100 million, costs us $100 million to train it, cool artificial tool, and if you want to use it, that's okay, but you got to play by our rules, and here are our rules.
All right, let's get into the specifics. I'm going to jump down to 8 because remember, we've got content going in, we've got content coming out. Microsoft says they do not claim ownership of captions, prompts, creations, or any content that you provide, post, or submit. So the stuff that you're putting in, but by using the online services, et cetera, you are granting Microsoft, its affiliated companies, et cetera, to use those captions and prompts. There's some license rights in there. There's some, to distribute, to transmit. Pretty broad in Section 8. What do you think about the language in Section 8 and what it means both for the user and how they're using it, but also if we're trying to create documents like this, how we might learn how to draft this kind of thing? Is this done well?
Is it done well? Boy, let me take that question last. Here's what's going on. Okay, Microsoft is getting sued already from multiple directions. People are claiming, hey, you stole my works, my copyrighted work. When you train this thing, people are concerned about what's going to happen with material that gets generated by Bing in this regard. And so Microsoft is really doing everything in its power to protect itself from liability. It's no surprise to hear I think that in and of itself is a very good idea. I think we are entering, I will be the 8 millionth lawyer to say this, but we are entering pretty uncertain times and uncertain waters around how companies that want to use AI tools can protect themselves from liability. So Microsoft is trying to be I interpret this as them trying to be very, very careful right here. So what the first thing they are saying is, look, we're not claiming we own any of this. They don't want to own any of this. They don't want to be potentially responsible for owning content that people are typing in to Bing. We'll get to some more of that later, but they don't want to own that content. But what they do want to do is say, look, we can use this any way we want. If we use this to train our systems further, we can do that. If we want to use something you type in an ad, we can do that. They want pretty unfettered access. One thing that's interesting to me, I will say about this, you asked about how well this is drafted. It appears to me, complete speculation, it appears to me that they're being careful not to mention a particular issue, which is using material that you type in to help train and improve the model. They don't, I'm looking carefully at this, but I don't see them mentioning that anywhere. That has been a big controversial topic with OpenAI. A lot of people are asking OpenAI, hey, are you using my data to improve the training? OpenAI has been a little bit cagey about that, and so it's not surprising that Microsoft does not want to touch on that issue. I'm going to stop and take a breath, Mike. I really threw a lot at you very quickly there. But the point is Microsoft wants to say, we don't own this, but we can do whatever we want with it. You type it in, it's up to us. Don't complain to us later if, for example, you see something you typed in an ad on television for Bing.
Yeah, and what's interesting is you see for me in the background is this question of the relationship between OpenAI and Bing.
Absolutely.
The ethos of OpenAI and of that space, of open source space, is that sort of nothing's original, and we all know that. So you see these even open source case books as a movement in law schools because nothing's really original. We're all this sort of collaborative, cumulative brain structure in society, and that's the ethos. But now there's a commercial opportunity. And so now you see Microsoft stepping in and actually using in direct opposition to what some people thought OpenAI was doing. Now we're using it in this context. If I jump to 7, it says use of creations. Subject to your compliance with this agreement, the Microsoft Services Agreement, and our content policy, you may use creations outside of the online services for any legal, personal, non-commercial purpose. Pretty specific, or not? What do you think?
Well, so I was actually quite interested in this. This is a little different from, for example, some other generative AI programs, like, for example, Midjourney. You sign up for Midjourney, and once you become a paid subscriber, you can actually use art that's created by Midjourney or created with Midjourney for commercial purposes. Microsoft here trying to shield themselves as much as they can. I don't know at the end of the day, as a practical matter, how much this really matters. But what Microsoft they want to do what attorneys call preserving the argument. They want to be able to say in court, if they get challenged, hey, look, we're not. This is not a commercial venture. People pay for this. They're supposed, the famous line. This is for information purposes only, right? Many of your viewers too young to remember this, but there used to be things like psychic hotlines on TV, right? And they would say, "Look, this is for information purposes only. Don't marry or divorce somebody based on what we're telling you. This is all for entertainment purposes." So what Microsoft is trying to do, they don't care. At the end of the day, they're not that worried that you're going to take what they did and write it on a flyer and post it around your neighborhood. What they're worried about is that they're going to get sued by more people, and that they're going to be stuck. And so this is a way for them to say, hey, look, we're offering this for people to use, but we are not engaged in a commercial enterprise with folks that are going to use this tool to create new content.
Yeah, it's kind of exciting because in a lot of this language, in 3, you can create a contrast for me. In 3, it talks about this being for entertainment purposes only. In 9, it says, we plan to continue to develop and improve the online services, but we make no guarantees or promises about how the online services operate or that they will function as intended at all. What do you think about the contrast in this language? Are we just playing here? Because it seems like somebody's making money.
Well, I think, first of all, people make a lot of money selling things just for entertainment purposes, right? So if Netflix makes a lot of money selling stuff just for entertainment purposes, I think what Microsoft is trying to say is, look, again, not to put too fine a point on it, but we're the ones with the big AI. If you want to use what we've got, that's fine, but we're going to put a lot of restrictions on you, and meanwhile, we're trying to eliminate all restrictions on us.
Yeah, let's go to 3. What do you think about the language in 3?
Okay. I think one of the key points about Section 3, and they kind of bury it there towards the end. I'm going to read the exact language. I'm just going to repeat what you said. Due to the nature of the online services, creations may not be unique across users, and the online services may generate the same or similar output for Microsoft or other users. Other users may also ask similar questions and receive the same, similar, or different responses. So that's a pretty anodyne language there. But what they're getting at is a fascinating but crucial issue about anybody who's incorporating generative AI. Randomness is part of this. Randomness is baked into this system. It's the nature of the beast, if I can mix metaphors or use more than one metaphor there. Part of what's exciting, but also what is somewhat risky about using AI tools, is you don't always know what you're going to get. And so I can type in a prompt this morning, I get one answer. Tomorrow, I get a different answer. That's actually, if you think about it, not very typical of what happens traditionally as we think about software, right? If I look something up in an online dictionary, I expect to get the same or very similar answer the next time I go to look something up. So Microsoft doing something very different there, and they're putting everybody on notice that, look, we don't know what this thing's going to do. you don't come crying to us if tomorrow it says something very different. Let's take something as simple as a chicken soup recipe. Hey, the chicken soup recipe may look very different when you ask for a recipe tomorrow, and that's just the way things are. You need to be on notice that that's going to happen. I think that they're using pretty neutral language to describe it, and part of the concern is that, again, they're already starting to worry that people out there are gonna start complaining and possibly try to assign some kind of liability to them because, hey, this thing's giving me inconsistent responses.
Especially if you have an expectation of consistency because you think you might get truth out of it. And I know you and our friend John Grant, who was on a previous episode of the show, had a conversation about the difficulty of using these tools in the context of contracts, because if you ask the same question and get two different answers at two different times, that tells you correctness is not necessarily the goal. Getting a good answer is really relative for tools like this. And if you have a context in which the outcome needs to be high quality, you don't know how much you can rely on this. And if you look at 9, they specifically say, we don't even promise that it's not going to infringe, right? We're not even going to promise you that the use of this thing won't be creating legal liability for you relative to other people. What do you think about that language in 9?
Well, so yes, there's a very kind of cagey thing going on here when it comes to copyright, because of course that is very much on the minds of everybody at Microsoft right now, because they are in the midst of several lawsuits about copyright, and I suspect there are more coming. And so they're trying to say you can actually look at 9, and then we've got another section where they are expecting you to guarantee that nothing you type in infringes, but they will not make the same guarantee to you. They're saying, hey, look, if you take this thing, you may very well wind up infringing on somebody else's copyright. Hey, don't come crying to us. That's on you. And actually, I know this is a topic that you've covered many times in the Contract Teardown show, which is one of the first lessons they teach you as a junior attorney reviewing contracts is, hey, try to make it mutual. If the other side wants indemnification, then you say, fine, but you're going to indemnify us. This is an interesting example where that's not the situation at all. Microsoft is expecting you to indemnify them if you enter in copyrighted content, but they are not going to extend that back to you.
Let's step back from the document as we do. I'm trying to think of who's creating the liability around here, right? Because Microsoft is saying it's not them. They're saying you better not. They're saying OpenAI is not doing it. Nobody. And yet you see a lot of these tools that are incorporating for point solutions, incorporating OpenAI, making huge promises about getting an AI lawyer, about getting an AI doctor, about getting whatever. These sort of experts that you expect to not get a nice answer, not to get a complete sentence answer that sounds like a human said it. You're expecting the right answer. And a lot of these marketing departments are creating language that sure sounds a heck of a lot like you're going to give me the right answer. But in reality, in the contract, they're saying that's not happening.
Right.
What do people expect here? What do you think is reasonable? Do we want the marketing language to make all these? Do the rest of us just say, buyer beware, we know that this probably isn't true, let's go read the terms? Or are we going to be realistic about that and hold companies like Microsoft, who are getting financial gain out of the use of these tools, who's going to hold the liability at the end of this thing?
I'm going to use careful lawyer language and say, boy, Mike, that is a fast-developing area of the law and a topic.
It depends, buddy.
It all depends, and there are many law firms that will charge you $2,000 an hour to say it depends, but they'll draw it out and they'll write it down for you in a much longer language. Let's distinguish at least two issues, right? One is copyright liability, and the other is liability for the content of the information. So that could be things like negligence, if it gives me bad medical advice or bad legal advice, versus, hey, I asked you to write a poem, and you Bing basically just took a bunch of song lyrics from John Lennon and Paul McCartney and turned that into a poem. So your question is really about that. We talked a little bit about copyright liability just a few moments ago, but your question is now more broadly what's going on with liability for these. Now, one of the things that we didn't talk to yet, but I want to find, is that Microsoft here is saying very clearly, you use these services at your own risk. That is, you use these services at your own risk. Now, it is tricky to do that, especially in one of these, no one is taking out a pen or using DocuSign to sign this. So how binding is this, right? You go skiing, they tell you you're assuming the risk of going skiing, but there's a limit to how much you can waive. Nobody knows what that's going to mean in the context of these AI tools. My suspicion, here we go. My suspicion is that the courts are going to take Microsoft's side on that particular issue. My suspicion is Microsoft has said, look, if you start taking some medicine because of something ChatGPT or Bing told you, and that's different from what your doctor said, we're not in that business, and you really shouldn't be coming after us for that. I think the copyright situation is a little less favorable to Microsoft.
Yeah, I'm imagining the moment on Star Trek where you say computer and you ask it something that you expect an actual answer to, and it tells you to go to a totally different planet for beryllium spheres. It is a fast-moving, super interesting area, and I want to point out in closing, as we get there, Adam, that we're exploring this as well. We're trying to figure this out because our users, whether you're outside GC, whether you're in-house, whatever your role is, students, professors, we're all trying to figure this out too. And we have sort of this dual pressure of we need to figure out how we're going to use it, and also we need to advise people on the risks of them using it. There's big watch this space energy. We're coming out with a resource soon that we worked with Adam on and some other smart people about how to do this, how to advise about the risks of these things, how to make conscious decisions, and using departments and your firms as a way to experiment, to test, to get familiar with these things, and also know the legal liabilities. So keep an eye out. We'll make sure that there's a link for people who want to connect with you, Adam. I know you have a newsletter that you talk about these issues, so share that. And also, how else can people reach out to you?
Well, you can track me down on Twitter at Adam David Long. Not Adam Long, that's a golfer who has quite deservedly
makes
is a much
more money
bigger
than both of us.
Celebrity than I am. But please check for Adam David Long. And then you can find me on Substack LawSnap at lawsnap.substack.com is where I try to update people on these kind of issues once a week. Got links to a bunch of other resources in there as well.
Great. We'll have links to both of those over at the show notes at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email us. We're at community@lawinsider.com. We would love to see you, and we'll talk to you all next time. Thanks again, Adam.
Thank you. Great to be with you.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.